Warning, we are not your attorneys. Please, don't take anything we say as legal advice. I'm Geoff.
I'm Mike.
And I'm Derrick.
And you are listening to the Not So Grand Jury,
which is now sponsored by Morwa P. LLC.
This episode, we're talking about episode 1 of How to Get Away with Murder.
Geoff's favorite show.
Oh my gosh. Isn't it?
Do you want to run through just a brief history of your history
okay.
with the show, Geoff?
So, me and this show, I've watched exactly 2 episodes of this show, but me and this show have a past. When this show first aired, I was doing my first podcast immediately after law school for us ended, for me and Mike, not for Derrick. There was a new law show coming out. I'm doing a legal podcast. That was All Too Common Law. It's not available anywhere anymore except for my hard drive, so sorry.
Future releases might be in the works. I'm excited for this.
Some very untimely news discussions.
Let's do some reloaded.
Telling a Supreme Court justice that he can go fuck himself.
I mean, that could happen now, but anyway.
So I watched the first episode of this show when it aired in October of 2014 and wanted to gouge my eyes out with a grapefruit spoon because it's so bad. It ran for 6 years. And I don't know how.
Without any spoilers, you could almost assume that they do actually get away with murder.
I presume so. I mean, yeah. I've, again, only seen the first 2 episodes. So I did an episode back then on why it was bad. And now I have some more people to talk to about it. And I can, much like The Ring, pass it on to you. And hopefully it will live in your heads instead of mine from now on.
I am so glad that you are bringing us into this, Geoff, because this is exciting. So for the record, I don't know, Mike, have you watched the full How to Get Away with Murder series?
I've only seen this one episode.
Okay, me too. So literally none of us are going to be able to add anything beyond episodes 1 and or 2, which is great. Oh, yeah. Because I don't plan to continue watching it unless one of you guys make me for a future episode.
No, we got no reason to. No SEO is coming from this.
No, I have no intention of watching any more of this show.
So, yeah, Geoff, would you like to give us an overview of episode 1? Because you can't go much further, right. So I might as well talk about episode 1.
So, episode 1 starts with some law students arriving. Forgive me. It starts with some folks having just committed a murder.
Maybe, Geoff. Maybe.
Or covering up a murder. They're certainly trying to cover up a murder.
There we go.
Or
maybe they just stole a dead body. We don't know. We didn't see the rest of the show.
Maybe. That's possible. They came across a dead body and decided. Then smash cut to first day of law school for these students, and they are walking into their criminal law class, and apparently the professor is a real hard ass. There's some talk about, law students and some cliches, and we'll get into that. And then the sort of arc of the season, I assume, is introduced when they are told by their professor that whoever wins this little contest she's got going on the first day of the first year of law school for these students, the winners will get to work in her criminal law firm. And then they have a little trial where several people break the law, and the teacher does a number of things that would get her disbarred pretty quickly.
Just a few ethics violations starting from the very first scene of the episode or second scene of the episode.
Yeah, pretty much. Just nothing big. It's really nitpicky stuff, And then
sarcasm.
And then there's more crime cover up, and someone walks in on somebody else receiving oral sex, and then the episode ends. It's It's crazy. It's crazy.
That's such a great summary. That's such a great summary. I love it.
Yeah. If the Too Long Didn't Read version, on the first day of law school, maybe the first couple days of law school, several law students become interns at a criminal law firm, which isn't permitted, and help win a trial.
There we go.
Sort of.
Shall I take away how close to accurate
Derrick,
it is with regard to law school?
Yeah. You've talked a lot on the podcast so far about this iteration of the previous about, running a small firm, all that kind of stuff. As a change of pace, talk to us about law school.
Yeah. So, listen, I only went to one law school, so I can only talk about my experience. But what I can tell you is that there's not a lot of things that are correct in here. So, let's start. We're talking about Middleton Law School, which is a fictional law school. I would like to think it's probably based on UPenn, if I had to guess. Hard to know. It's actually filmed at USC's campus. So, for the record.
Sure.
But I don't know what Middleton Law School is. I don't know how high it's ranked in this fictional world we're in. But what I can tell you is that not a lot of things are correct. We see about, in this episode, we see about, give or take, like 10 minutes in a classroom. And there's a professor, which is correct. There are students, which is also correct. And that's about as much as it gets in terms of doing like the actual things correctly. I mean, there is cold calling. So for those of you who are listening and went to law school, I apologize for the Vietnam-like flashbacks. For those of you who did not go to law school, you're going to learn a little bit about how we learn when we are first-year law students. I always sort of thought of law school as like there's sort of three parts. There's first year, second year, third year. The first year is where they try to scare the living crap out of you and sort of, if you are not sure whether law school is your thing, you're going to find out really quickly. And are you willing to put the effort in to get through the first year of law school? Once you've got through the first year of law school, then the second year is where they sort of try to run you out by overworking you. And then the third year is, well, you've done everything now. Now just steer into the sunset. If you want to actually try to do something that is more practical for what your future job may be, fantastic. But if you're more perfectly fine with sliding by, Derrick raised his hand. Third year is not a whole lot. That's sort of how that works. So
I've heard it described as the first year they scare you, the second year they work you, and the third year they bore you.
There you go. That's exactly right. And I feel like that's what a lot of people think. And law school, there are a lot of criticisms of law school, including that they emphasize the theoretical over the useful, and you don't really actually learn how to lawyer. You learn how to think. You learn how to critically think. You learn case law, which for a good chunk of law students will never learn cases ever again. But nevertheless, like, it is very much a theoretical thing. But one thing that they do get correct in this show is the concept of cold calling, which is just professor walks up, start asking questions, starts pointing at random people, and says, answer the question.
So we've established the actus reus. What was the mens rea? Wesley Gibbons.
The mens rea? Right.
Day one and you're unprepared?
That is certainly something that I believe a lot of law schools do, and it is one way to scare the crap out of you your 1L year. I'm sure we all can recall stories from either friends or yourself that came out of cold calling incidents. I personally have one, sort of. It sounds like I blacked out part of it, but my second year so it wasn't the first semester of law school, but it was the second semester of law school. I got called on probably 20 minutes into my civil procedure second semester class and had not prepared for it. And I will be honest, to this day, I do not recall exactly how that Q&A went down. I just know I wasn't prepared. It probably didn't go great, which is probably why I blacked it out, because I don't want to actually remember that. So, like, the incident that happened with Wes, where she calls on him, he's not at all prepared. It turns out the reason he's not prepared is that he literally just got off the wait list.
Day one and you're unprepared?
No. Well, yes, but I didn't know there was anything to prepare.
I emailed the assignment to the entire class 2 days ago.
Oh, I didn't get that. I only got accepted here 2 days ago from the wait list. So that's probably why you didn't get my email address.
Which is something that totally happens. Like, I know multiple people that showed up even day 3 or 4 of law school, having gotten into the school later on. That is something that definitely happens, and you're not prepared, and sometimes the professor will grill you. And in fact, she was actually trying to give him a little bit of a learning experience, like to sort of walk him. I mean, she did it in a mean way, but she's walking him through actus reus versus mens rea, blah, blah, blah.
Well, yeah, walking him through concepts that usually you're a couple weeks in to criminal law before you're really diving into mens rea, actus reus, and those kinds of things.
Correct. That's usually not something you would be discussing scene 1, day 1 of law school.
I'm going to disagree only in the sense that I don't remember what was taught on my first day of criminal law, but like you could, you have to teach something. If you're teaching one specific issue, you could teach actus rea and mens rea. It's not like that crazy of a concept to teach that day 1.
Sure.
No, fair enough.
I think it's, I don't think it's crazy to teach it day 1. I think it's crazy to expect students to walk in understanding it day 1, because they won't.
It could have been in the reading. You had assigned reading to read day 1, and it was just about mens rea and actus rea. There are lots of other issues in this episode. I'm going to say this is the one that I think is like not really that much of an issue.
And I'll be honest, it's one of the few things they do get right. That's it. And now
I want to split hairs with it, but I won't.
I mean, they get it mostly right. Let's put it that way. How's that sound?
All right.
I'm now going to stop talking about the things they get right, because I'm done. That's
You've exhausted.
I've exhausted the few things they got right. Let's discuss some of the things they didn't get right. So let's talk about the guy that said, "I spent the summer interning for Chief Justice Roberts."
Forgot about that.
I threw up 4 times this morning, worried she's gonna call
she's a
me.
ball buster, sure. But I spent my summer interning for Chief Justice Roberts, so...
Dershowitz has the upper hand in the academic world, but Keating's clearly the better defense attorney.
Pre-law school, summer before law school, you interned, quote unquote, with Chief Justice Roberts. 1, not a thing.
Nope.
Step 1, not a thing. There's no such thing as interning for the Justice of the Supreme Court. You clerk for the for a Supreme Court justice, or for any judge. And if you clerk, it typically means you have graduated law school, and you are
left and passed the bar.
You have passed the bar, and you are able to clerk, or you've at least graduated law school. You may not have actually passed the bar, or you may have actually gotten admitted to the bar yet, but you have certainly, you have a degree. You are a JD. So that's not a thing. So presumably that guy's full of shit, but even if he's correct in this fictional world, that's not a thing. It appeared that most of the people in class were either in full suits or otherwise dressed to the nines day 1 of class.
That was weird.
Well, so here's the thing. My experience is a little different, because I actually, at Cornell, I was in the dorm that connected to the law school. So putting on pants was an issue. Like, that was a lot. So, like, in the middle of winter, I'm in t-shirt, shorts, sandals during my classes. So clearly that was not something I'm sure that's not normal, but nevertheless, I would say a vast majority of students in U.S. law schools are in casual clothes.
They dress like college kids. There was one guy in our law school that, like, the orientation day, showed up in a suit.
Well, every law school is required to have one person who weirdly wears a suit all the time. That's actually a requirement of law school. We had the same guy. He was in my section.
It's actually the law.
It's actually like every law school has to find that guy.
So like jury duty. You get the letter, and you have to be the one that wears a suit all the time.
Right. Correct.
Yeah.
So this class, criminal law Professor Keating says that she, unlike her fellow professors, she's going to actually make you learn how to practice the law.
Unlike many of my colleagues, I will not be teaching you how to study the law or theorize about it, but rather how to practice it in a courtroom, like a real lawyer.
Well, actually, one, I get that it's a cool general concept. That's not how it works. In fact,
it'd be good if the criminal law students knew what crimes were.
Step 1. Let's talk about step 1. That's why we do the studying and theorizing, is so that you actually know what criminal law is before you then learn how to practice criminal law. Law schools teach theory, and they teach you basics, and you study the law and learn the law before you practice the law. It's interesting that she goes, day one law school, we're going to practice the law. And it's like, okay, yeah. Good luck with that. Day one, here's how to defend a murder suspect is not a thing. Let's just go with that. She encourages the students, or in fact requires some of the students to skip other classes to go to an actual trial.
That blew my mind.
See you in the courthouse at 9.
Oh, Professor Keating, we have torts at 9 tomorrow, then property at 11, so I'm not sure
The way you're whining right now makes me believe you think I'm your mother, Miss Pratt. Show up tomorrow or drop out of the competition. It's that simple.
That's not gonna fly.
You're going to be hated by every other professor.
You would be fired.
Yes.
Yeah.
You would be fired so quickly.
There is not a torts professor in, I think, the country that would be okay with another professor mandating that the students skip their class.
Especially, it's day 3 of law school.
Yeah.
There's no professor or teacher at any level that would be okay with one teacher at the start of class being like, and you don't have to go to your next class. Like, yeah. What would the situation be where that would be acceptable? So,
I don't know about you guys, but like, at least in my law school, a few of my professors took active attendance to make sure you showed up. Not all of them did. Some of them were like, if you don't want to show up, you're an adult, you don't have to show up, but then you don't know what the hell's going on. But some of them took active attendance every class, and like, you got docked if you didn't show up. I'm also confident day 3 of law school is a perfectly good time to go to your classes to know what the hell is about to happen. Maybe it's just me.
Yeah.
So that's absolutely ridiculous.
I will say at our school, a lot of the classes were also recorded, so you could log into your student account and watch the torts class.
That was not a thing for us. Interesting.
Well, you're much older than me.
I am so much older. I am a more mature lawyer, Geoff. Let's go with that. Mm-hmm. Let's go with that. I'm not. Anyway.
I don't think that's true at all. Sponsored by More Law PLLC.
Maybe not a more mature lawyer than Jeff Blackwell. Okay, good. The other thing I want to mention, it's not in the class, but I think it's very important to bring up, is in the opening sequence, where again, as Jeff said, the students are presumably trying to hide a body in the sort of future, but it's like a flash forward as the introduction to the series. It turns out, we believe that one of the students, Wes, pulls out something that apparently could be the murder weapon. And the student quotes Commonwealth v. Deloach for that oft-forgotten principle that finding the murder weapon makes it easier for the prosecution to convict someone of murder.
Sorry it took so long. I went back through this.
You can take that back right now.
No, it's smart. Commonwealth v. Deloach. The case the prosecution should have won but lost because there was no murder weapon.
So what are you saying?
We clean it and we put it back. Hide it in plain sight.
I don't think you need a case for that very difficult principle.
Mm-hmm.
I don't think there's a... Now, again, I don't know when this is in the timeline. It could be like a couple days. It could be months down the road. I don't exactly know. But what I can 100% tell you is that no law student's quoting a case for the concept of finding the murder weapons better for the prosecution.
Yeah. A little bit more about law school. The cases that we read in law school are appellate cases because you're especially in criminal law, you're not going to have a decision from a judge to read. You're going to have a jury verdict that says guilty, and then some sentencing stuff. So if you're reading a case in criminal law, it's something that has been appealed from the trial court to an appellate level court, and the appellate court has, looked at the law and issued a decision. And in criminal law, in criminal law, it is virtually guaranteed that it's going to be the defendant appealing a conviction because the prosecution can't appeal an acquittal. They're constitutionally prohibited. Once you have been acquitted of a crime, you're done. So the idea that the prosecution would have appealed a case that they lost because they didn't have a murder weapon. Like, that's not even an appealable issue, for one thing.
Right.
But the prosecution can't appeal a loss.
Right.
So you wouldn't have anything to read.
Listen, for those of you who have went to law school, you are fully aware that there are cases we read that are the pinnacle of that case, or the most important thing to that sort of, we remember International Shoe from Civil Procedure that was a Supreme Court decision that talked about like the ability for a plaintiff to sue an out-of-state defendant and allow them to come in and defend the lawsuit. Palsgraf versus Long Island Railroad, which is one of my favorite cases. I don't know if you guys remember this in torts, where guy tries to get onto a train with a sort of random package.
Oh,
he
yeah.
He gets shoved onto the train by an employee. The package falls onto the railroad tracks, explodes because it has fireworks in it. Why wouldn't it? Which then causes damage to a person at the other end of the platform, which was completely unforeseeable. And that was a decision as to whether or not the plaintiff can receive damages from someone because it was completely unforeseeable and, blah, blah, blah. And then there was...
I think, like, because the blast, something fell on her?
Yes, the blast hit something and then it fell on her and caused injury, I think, as I recall correctly. Funny enough, Cardozo decision. Fun fact. Oh. And then so Palsgraf's one of my favorites. I think Pearson versus Post is my favorite with property. The concept of hot pursuit and pursuing a fox as to whether you have claimed the fox by chasing it and you've gained possession of the fox.
Man, these are cases I do not... I remember reading these, but it's like 10 years ago, and I hadn't thought about them in a long time.
There is no reason you would have thought of these cases because they are ridiculous, and they are the background to a legal principle that we just now know the principle. The Pearson Post one, which I think was 1805, was just a hilarious case that basically a guy and his friends were chasing a fox. They were in hot pursuit of chasing the fox, which is the first and last time I've heard of the phrase hot pursuit. Another guy came in, killed the fox, and they said, no, it's our fox, we were chasing it. That's the whole case. And weirdly, the guy who was chasing it won at the trial court level, and the other guy appealed, and they were like, no, you killed the fox, you're entitled to the fox. Fun times.
Yeah. You loosened the top of the jar, you get the jar full of fox.
It's kind of funny. But anyway, so law students will remember those cases. We won't cite those cases. Those, for the most part. No. There are some Supreme Court decisions we obviously cite regularly for constitutional law principles and things along that nature, but you're not citing cases for, legal principle concepts, especially not in criminal law for the most part. So anyway, that's also completely ridiculous, especially for the principle that it was cited for, which is murder weapon bad for someone who might have committed murder.
Yeah, and the idea that, the reason that comes up is, it's genuinely hard to prove a murder case without a murder weapon. Not impossible, but,
yeah,
it's an element that they want to have at the trial.
Did we not just talk about that for the Lincoln Lawyer?
Yep.
You don't have a murder weapon, that is number 1, 2, and 3 on the defense. Where's the murder weapon? That is literally what they would do in opening, closing, you name it. So, yeah. Right. But I don't think you don't need to cite the Commonwealth v. Deloach in order to indicate that. The one thing I want to, before I move on from the law school and we can talk about her criminal practice, is, so in the second day of criminal law, she asks every single student to come up with a theory as to, what theory they could use in the courtroom to defend her client. And she says no one can use the same one, so they have to keep coming up with different theories.
The trial begins in 2 days. So tomorrow, each of you have 1 minute to present the best defense for this case. See if you can beat my current plan.
So there's, give or take, 100 students, maybe a little less, maybe 75, but a fair amount of students who are coming up with theories as they go. And in the end, she basically says to them, none of you did what I did, which is...
Step 1, discredit the witnesses. Step 2, introduce a new suspect. That person is Mr. Kaufman's jealous business partner, Lionel Bryant. Step 3, we bury the evidence. We throw so much information at the jury that they walk into the deliberation room with one overwhelming feeling: doubt.
That's not how you bury evidence when it comes to like discovery. There's not a thing to bury evidence in front of a jury if the prosecution's even halfway decent.
It feels like this show was written by somebody who, a lot of these shows will have, a lawyer on staff or a lawyer on call that they can talk to about things. It feels like they just watched a couple law things or a couple law shows without taking very good notes, because there is a thing where it's like, oh yeah, you bury the opposition in 10,000 documents and let them try and figure it out.
Yeah.
But just the idea of we'll bury the jury in evidence is well, no, the jury has to make a finding at some point. You want them to find a certain way. You want to bury them in good evidence, I guess.
Bury the evidence means two possible things. One, in discovery, where you slam the other side with documents, or it means something illegal, where you literally bury evidence and don't let the other side, don't let it see the light of day. Either way, that is not something to teach a criminal law class. But also, let's even assume that is a thing, that burying the evidence is a thing. You're telling me that between 100 students, no one thought to discredit the witness and or add a third-party suspect? It's not that amazing of a theory that it would have been oh my God, what a possible theory.
I remember I took trial advocacy in law school, and the first thing that it comes up in evidence too, the first thing you want to do when you're cross-examining someone is discredit them. That is step number 1
right.
on cross-examination.
Right.
So the idea that, again, this is their third day of law school now, so they might not know how to discredit a witness, but discrediting a witness, this is the most basic criminal law strategy.
Yeah. And also, I'm giving credit for the fact that apparently all of them already know everything about criminal law based on the few snippets we get.
Yeah. The 2 hours of class that they had.
None of them would know that day 3. None of them would know this on day 3, or day 2, whatever it is. Shoot, I still don't know half of the stuff they came up with, but because I don't practice criminal law or care about criminal law. But let's be honest, her looking at it as a lawyer, what she and her team came up with is just literally 101 how to defend a suspect.
I can't say I blame them, because apparently they've only had this case for a week, but the fact that apparently we go through 100 students all throwing out, their unique defense for the case, and only the very last one, Wes, she made him go last for some reason.
Because he wasn't prepared the day before, so obviously he has to go last day 2.
Right. He's the only one who says self-defense? Really?
So, the way I see it is, we say it was self-defense. And we do that because, Gina was suffering from Stockholm Syndrome, which is actually quite common in assistants with demanding bosses. The affair was just one example of how far Mr. Kaufman's brainwashing of Gina went. He made her fall in love with him. So in this way, her poisoning him was an act of self-defense.
What were the other ones arguing?
There aren't very many affirmative defenses out there. So if you literally
right.
Googled list of affirmative defenses, I'm confident that self-defense is in the top 4.
But also, the facts of how this person died is they were poisoned, right?
Yeah, I think they were something to do with they were given aspirin, but they're allergic to aspirin. So something like that.
It's difficult to argue self-defense there.
It is.
He was charging at me from across the room, and I threw the aspirin really hard, right as he breathed.
But went straight down his throat.
But was he in hot pursuit?
I was going to say that she turned off her targeting computer, and
there we go, perfect.
Threw that aspirin right down his throat.
What I will say is that does segue very well into her criminal practice, because it's at this moment, after she tells them what theory they're using, we then segue into the trial.
Right.
And I think that's a great time for you, Geoff, to take away her wonderful, completely accurate criminal practice.
So this, I'll start at the very basics. It's very unlikely that you're going to have a criminal law professor who also has an active criminal practice, because law professors tend to be full-time law professors. Now, there are adjuncts that teach like one class that's an elective class, and you probably aren't having to grade hundreds of exam essays or anything like that. But it's incredibly unlikely that you're going to have a professor also be a practicing criminal attorney, because their schedule is going to be crazy. We just saw Lincoln Lawyer, where it's like he's bouncing around from court to court, which is not unrealistic. And so, she would probably wind up having to miss a third of her classes, which is not a great way to be a professor. Anyway, so that's problem number one for her. Problem number two is she's bringing in 1L law students to work at her firm, apparently during the school year of their 1L year.
Every year I choose 4 students to come work for me. This assignment is used to help me decide who that is. Now it's time to find out who will be joining us in our firm. First, the standout in the class, and the one you should all make it your mission to destroy. Come get your prize, Mr. Walsh. The other ones joining us will be Asher Millstone. Yes. Michaela Pratt.
Oh, thank God.
Laurel Castillo. And because our workload has grown, I decided to hire one more of you. And that one will be Wes Gibbons.
Now, I'm going to back up a little bit, because this is true of criminal firms, law firms that practice criminal law, and law firms that practice, civil litigation. Generally, first-year law students don't have jobs, part-time jobs, or what have you. There used to be, until actually pretty recently, there was a rule from the American Bar Association that law schools couldn't allow students to have internships or clerkships or what have you during their first year. The idea being that they really need to be devoting their time to studying the essentials of law school, because the 1L classes are mandated by the ABA that they have to be taught. They're going to be on the bar exam. Students need to be giving that their full attention. The ABA has done away with that rule, but my understanding is most law schools still maintain that rule, and I would hazard to say almost all law schools still have that kind of rule. So it would be most likely prohibited for her to be able to bring in law students. What she's absolutely prohibited from doing is bringing her entire criminal law class into her office to sit down and question her client.
I walked into his office when I just screamed real loud, because Arthur was standing there behind the door. I thought he was going to be pissed at me, yell, but instead he just started laughing. So then I started laughing, and, well, that's when he kissed me for the first time, and, yeah, I became that girl.
Something tells me she's always been that girl.
It was on my last day working for him when I came back from lunch and saw the paramedics.
If you are a criminal attorney and you have a client in front of you, you have, by the way, a couple of days before this client is going to be tried for murder. You're not going to be taking time. Well, first, you're not going to be taking time to corral all your law students, bring them in, and have them answer or have them ask questions of your client, because you've got better things to do. And you should be disbarred for doing that. By bringing in anybody outside the law firm to talk to your client, you're breaking attorney-client privilege. She lets them go through, in order to come up with their defenses, she lets them go through her case file, that the discovery materials, all of that.
So in theory, they could be hired by the law firm to be intern or whatever, and then they would be a member of your law firm. Does not have to be an attorney for them to know facts about the case without breaching attorney-client privilege. You can have your paralegal in the room with you taking notes or something, and that wouldn't breach your client privilege. So
yeah, and I would wager she isn't paying 80 students or however many are sitting in her office right then. Also, I think if someone did that, then there would be a strong argument to be made to the court that these are not actually, even if she paid them all $1, it's not.
You can't. Yes, if you have. I mean, if you've disclosed confidential facts to somebody else outside your law firm, you can't simply hire them for $1 to make them part of your law firm to, alleviate that fact. Man, that was, as soon as that happened, it was like, what the fuck?
Yeah. Talking about her law firm more beyond just this trial, beyond her practicing while also being a law professor. I would say the structure of her law firm seems a little bit more accurate than, say, what we got in Love, because in that instance, Rachel Lee Cook's character in Love Guaranteed was a solo practitioner with both an accountant and I think a legal secretary renting a big office in like downtown Seattle or something. Really, really unrealistic. Not that can't happen, but it was clearly whatever. We'll talk about that again in the future.
Yeah, we'll bring back up Love Guarantee because I love that so much. We might as well keep going back to it.
So she's a well-established, well-respected criminal attorney. She's got two associate attorneys. Associate attorneys are attorneys that don't own own a stake in the law firm, because then you're a partner. And she has two associate attorneys, and as far as I can tell, no support staff, which is interesting. But I would rather a small firm have, multiple attorneys and they all just handle their own emails and whatnot versus one attorney and several support staff. Anyway, and there's apparently rampant sexual harassment going on in her law firm. One associate says to another associate not to sleep with the students this time.
We get a lot of you around here. Smart, idealistic girls who come to law school to help the less fortunate, only to take a corporate job after graduation, which they then quit the second they get pregnant because they'd rather stay home for the child, of course.
You're a misogynistic ass.
Stop screwing the students.
Yeah.
They also don't lock their doors when they leave the office, apparently. Or at least one associate is in the habit of not locking the firm's door at the end of the day, which is a problem.
Oh, I didn't even notice that.
Hey. I'm so sorry. The door was open.
Oh, kill him. Why are you here?
It can wait.
Frank, you didn't lock up again.
Yeah, because Wes barges in with his brilliant idea that they ask for a directed verdict, which is a criminal procedure thing that is just, it's in the rules of criminal procedure. You can just read the rules and it's like, oh, the directed verdict's a thing. A directed verdict is where you say to the judge after the prosecution has finished their case, they didn't prove the things they needed to prove. This shouldn't even go to a jury. It's a thing. It happens very occasionally. But the idea that he would get this revelation and then barge in at what appears to be the middle of the night.
Geoff's very unhappy. I just see it in his eyes.
This is painful to watch.
Yeah.
It's just, I'll say now again what I said when we did Love Guaranteed, and it shouldn't be on the back of these the people who created this show, wrote the show, directed the show, but when you're giving such terrible representation of what our legal system looks like, you're doing everyone a disservice. It is absolutely horrible. The idea that she would take on a client a week before a trial, not get a continuance, much like Mickey in the Lincoln Lawyer.
Why is that a trope? Why is this I've talked about this before, how I kind of want to track the tropes that we see. And it's like, so
yeah,
the hearing's happening in a week for some reason, like we're just starting to work on it right now. And also, going to law school, if you do well in my class, you'll win this position at my firm.
Yeah. They're, I guess, dramatic, because if it was, oh my gosh, we just took on a client and the criminal trial starts in 3 months, which is still, not the longest period, not a great amount of time to prepare a criminal trial, is less dramatic in a, visual sense.
Yeah. Maybe it is just that it's easier to like have the pace of the show instead of showing like a time lapse of the 3 months of work going into it.
Yeah, or find some other way to make drama than lying to everyone about how the world works.
Geoff, guess what the Rotten Tomatoes ratings is for the show?
87.
88, actually. You were shockingly close.
80, oh, really? Okay.
Yeah, 88.
I was expecting like a 90-something.
Shocking. I'm looking at this season now. So for this season, it was only 84 or 86 for the audience rating.
And again, there's a reason why this ran for 6 seasons. Someone liked it. I don't think lawyers did. Now, I will say, like, I've actually looked up, and there are certain like people who have written commentary on the show as a lawyer and liked it. And I can't see it because I can't look past how ridiculous it is. At all.
It's just, so much is wrong. So much is bad. Right. And we're about to, Mike, I think you're going to be talking about like the shit they pull in the trial that would also get her disbarred. But
it's just bad.
I don't know.
It's just bad.
So I've gone through like the issues that irked me about how her law firm works. Derrick, you run a law firm. Do you have anything that you want to add to this?
I mean, what I'll just say is like, to go sort of briefly back to something you said about like who is in her firm. So it's like herself and then presumably like 2 associates / whatevers, right? Like that is theoretically, you can run a law firm with that, right? What I don't fully understand is how she can then teach criminal law in addition to it. I run a firm. I have contemplated at times applying to be an adjunct professor somewhere, which is very different than being a full professor at a university, right?
Yeah.
Because if you're adjunct, you're probably coming in once a week for 1 semester and doing like a 2-hour seminar. And you're likely talking about something that you're adding expertise to. So you don't have, so like there is preparation, but like, the area. GCs at universities will teach law of higher education. They literally practice that every day of their life. Like they're able to talk about it intelligently, blah, blah, blah. I know like at my school, we had an adjunct that got really specific into like intellectual property law. And again, it's a person who practices IP law day in and day out. They were able to, like, they obviously had to prepare the materials, prepare the readings, but they were able to articulate their, specialty very well.
My discovery professor was a magistrate judge.
Oh, that's fun. Yeah. So, like,
federal.
And I would say most adjuncts are like they're bringing something to the table that makes it more interesting. And I will say, many law students have said their favorite classes are with adjuncts because you get to know a little bit more about the practice in the area. Not always, but certainly sometimes. I would have to think very hard as to whether I would want to adjunct to make sure I have the time to give to it. Now, this woman, I don't think they say if she's an adjunct or not. I'm pretty confident, 1, criminal law shouldn't be taught by an adjunct, step 1.
Yeah.
So if she's actually a full-time professor, that means she's not just teaching criminal law. Theoretically, she's teaching at least one other class, if not another one. But
right, she's probably teaching a separate criminal procedure or the federal crimes.
Right,
any number of different things.
Any number of things. In addition to running a practice, no, sir, that is not something that happens. In addition to the fact that we've talked about this before. Typically, criminal practices, you have more like little things you have to do. You have to, like, you typically have every day you've got some type of thing you're going to court for almost, right? Like between all of your different clients, I would have a hard time believing, like, even if her associate there could actually go to some of them, they couldn't necessarily cover all of them. And sure as shit, they're not focused on just one case for 4 days. Like, there's no way they could pull that off, given, especially if her practice is at all successful and she has enough money to pay them to do jobs. So, assuming she has a successful legal practice, that means she needs to make money, which means she needs more than one case. And it's also unclear how much.
And that case needs to last longer than a week, because even if she's billing $1,000 an hour, there are only so many hours in a week that you can support a law firm with.
Correct. I'm also curious how much money she had to pay her, but that's like that's always a fair question.
Although by the end of the episode, it seems like she is maybe somehow in cahoots with the victim's wife or something, and so maybe she's getting
So maybe there is
money on the side to who knows.
I mean, I wouldn't be shocked by that, but nevertheless, like in terms of the practice, like as a theoretical matter, her practice could exist, but as a practical matter, there was no way that practice would be a successful legal practice unless she did not sleep ever. So, yeah.
Hi everyone, Derrick here with a brief message. The Not So Grand Jury is sponsored by my law firm, Morwa P. LLC. One of Morwa PLC's many practice areas is business law. If you are a business owner or someone who is thinking of starting up a new or side business, you need a legal team who can efficiently provide you legal counsel, keeping you and your business away from potential legal issues, and if necessary, representing you in any disputes that do arise. We pride ourselves on being cost efficient while also getting to know our clients. If you want less stress and more support, you need more law. If you would like to set up a free consult, please click on the link in the show notes, visit our website, www.mooreatty.com, that's mooreatty.com, or email us at contact@mooreatty.com. And now, back to the show.
All right. Do we want to jump into the trial?
Yeah, jump into the completely normal trial. Yes, please.
Yeah, all right. So it is truncated. We don't see everything. I guess to the Lincoln lawyer's credit, this skipped voir dire, along with I think it skipped opening statements too. It skipped a whole number of issues. But the things that jumped out to me as giant legal issues that are committed during the trial. One, the Brady violation. The prosecution has an obligation to turn over exculpatory evidence to opposing counsel. I suppose in this case it's not exculpatory evidence, but this is evidence that was going to have to be admitted anyway. There was the video of her buying prescriptions.
So you got the footage from the convenience store when, Detective Gill?
It was 2 nights ago. The store owner had seen the defendant's picture on the news, so he went through his old surveillance tapes and just found this footage.
Footage that I will now play for everyone. There. The night before the murder attempt, Miss Sadowski bought... What does it say on that label, Detective Gill?
Zaloxacor. It's a brand of aspirin.
But she was completely blindsided by evidence that she should have been aware of beforehand. Either she's a terrible attorney for not requesting it, or the prosecution was committing an ethical violation by hiding it somehow.
Explain, if we want to throw it back in there, explain what exculpatory evidence is.
So I guess this is not exculpatory. I said that, but it's not actually exculpatory evidence. It would have been if they had evidence that it actually was self-defense, that the guy said, I'm going to kill you. Also, I'm holding my mouth wide open right now, and she threw the aspirin in there.
Another example would be the email that she had, the email that she finagles into evidence.
Mm-hmm. Will you please read this email that you wrote to Mr. Kaufman?
Dear Arthur, consider this my official request that you step down as CEO. I've warned you about having sexual relations with employees of
Your
this
Honor,
company.
this email was not part of the discovery file.
Is this true?
I thought it was. Although my associate is more familiar with the paperwork on this case. Bonnie?
Oh, my God.
I found the email and the files given to us by our client's previous attorney, Your Honor. I just assumed it was part of the discovery file.
It wasn't, which means it was obviously obtained illegally.
Enough. Did you write this email, Mr. Bryant?
Yes.
Then I have to side with the defense here. The email's admissible.
Your Honor.
I've made my decision, Mr. Williams.
If that was an email that the prosecution had a copy of, which is not clear because it's an email just from within the company and the prosecution probably isn't sifting through all the company's emails, but that would be exculpatory evidence. It's something that makes it less likely that she was the one who did it. And by the way, that's under Brady, that's not up to the prosecution to decide. Like, if anything could in any way potentially be used by the defense to help the defense, the prosecution has to hand it over. They can't say, well, we didn't think it was exculpatory because X, Y, and Z. That's not their call.
And if the prosecution
in theory
is any good, they would probably be overly cautious about proactively turning these things over because they don't want to leave an easy avenue to appeal. And failure to turn over some evidence is an easy avenue to appeal.
Oh yeah. Yeah. When I was in my third year of law school, I interned at the U.S. Attorney's office that was like across the street from the school, and I sat in on one of they called it a show and tell. They sat down with a defendant in one of the she may not have been charged at that point. I can't remember, but they sat down with a co-defendant, let's say, and just laid out, look, this is the case. This is what we know. This is what we're going to present to a jury. You can cooperate with us and help us out against the person who's actually orchestrating this, or not, and try your luck. But this is what we've got, and it's pretty damning. And I would expect that that's what something similar would have happened in a case like this, where they're like, look, this is the aspirin that he took. Here's you the day before buying a bottle of aspirin from whatever pharmacy, and also all the other evidence. Say, take a plea or something, and don't make this hard on yourself.
And all sides want that to happen. Any trial, both sides are kind of trying to find an easy out. Very rarely do cases actually go to trial. So,
right. And we talked about this in Lincoln Lawyer. There was no reason for him to. I don't remember what the evidence was.
It was
that he sat on.
Was it the gun evidence? It was the it was the gunshot residue. Because the guy had been sitting in the prior person sitting in the car had shot off like 100 rounds of ammunition, so that got on his current case's client's body.
And there's no reason to sit on that evidence.
Well, there is. It's more dramatic.
Sure, and I guess his client really wanted a trial for reasons.
Yeah. Other than turning over evidence.
One student sleeps with somebody at the business that is owned by the victim. The victim didn't die. The victim is still alive, but in like some sort of, not a vegetative state, but something
off screen.
It seemed like. Yeah. Well, they appear, he's in the courtroom at the prosecution's table for some reason.
Right.
Because that is how prosecutions work.
He's not doing great. Let's put it that way.
Sure.
Right.
Yeah.
Yeah, because typically the prosecution table has the victim sitting there.
Derrick's being sarcastic.
Your Honor. See?
There's 2 times that the students are gathering evidence for her. One of them, the student sleeps with one of the victim's employees or coworkers, and the other one, they went to the doctor's office and lied to them or something. I'm sorry.
They called that. So they didn't commit a HIPAA violation. They committed insurance fraud.
Oh, yeah. Okay, you're right. Yeah.
They called up the witness's insurance company and posed as a medical provider.
I saw she was wearing glasses in one of her Facebook photos, which got me wondering about her eyesight. So I called every optometrist covered under her insurance, found hers, then pretended to be a claims provider to get the receptionist to admit she has a condition called achromatopsia. It causes color blindness. Step 1, discredit the witness.
I might as well hand you the trophy right now, Miss Pratt. But I won't. Not until I see how the rest of you step up your game.
Well, just
I'm just saying.
add it to the list. I mean,
added to the list with the insurance fraud that she then sanctions her student doing.
I don't think there's a you see a blue shirt and think it's white. I don't think that's a colorblind. Like that's a type of colorblind, but whatever. Anyway.
Okay.
Insurance fraud. If you're
wire fraud because it was over the telephone.
I mean, the ethics violations that are occurring just from like, if you are committing criminal acts to gather evidence for your case, probably it's going to be an ethics violation for you later on, in addition to the criminal violations, I guess.
And so we know from the beginning of the show that she's regarded widely as this notorious hard ass. She seems to have been practicing criminal law for a long time and teaching criminal law for a long time. And so her students know she does this kind of shit. And her students, some of them become prosecutors. Yeah. And will know she does this kind of shit. Like, she would be disbarred so quickly for almost everything she does.
It would take one of the however many students are there to submit a ethics violation, like to submit it to the bar. That's all it would take.
And guess what? If you're a law professor, students get mad at you. You give them bad grades. You call on them when they didn't want to be called on. Who knows? I have an easy way to get her not only fired, but disbarred and never able to practice law again.
Well, and let's be honest, in the law school, you sort of learn very quickly that lawsuits and complaints are the way to get stuff done. And if you're mad and you've got proof of that, that is an easy way for and by the way, it's not like she hasn't probably done this before, I'm guessing.
Oh, yeah.
Like, this isn't like this is her first day ever study, like, being a professor. No, like, it implies she's done it previously. In fact, Bonnie, in her firm, was previously a student that kept going. So we know for at least a few years she's been doing this, and likely has done something very similar in terms of the ethics aspects. So it'd be mildly shocking she hasn't had bar violations brought up already.
Sorry, I derailed your conversation.
Oh, no, you're fine.
Like I said, this has been living rent-free in my brain for a decade.
All right, so Keating's big trump card to help win the trial is putting a police officer on the stand and having him, what did he testified against the other officers or, like, testified in her favor.
Where were you 2 nights ago, Detective?
What?
2 nights ago, when Detective Gill acquired the video that supposedly incriminates my client. Weren't you supposed to be working at the precinct as his direct supervisor?
I was.
And were you there?
No, I was not.
Where were you then? Home, perhaps? Taking care of your wife? I hear she's recently been diagnosed with cancer.
I was at a friend's.
Okay. I only ask because there's something I find strange about the chain of custody on this video. Detective Gill testified that he received the video from the store owner at 8 p.m. But the logs say he didn't log it into custody until 2:09 a.m. Don't you find that time gap odd?
Sometimes it takes us a while to log evidence into the computer.
Because you're all so busy. Visiting friends and such. Detective, in your 12 years working for the city of Philadelphia, have you ever known them to alter video footage to help the prosecution get a conviction?
Objection.
Digitally altering aspirin labels, for example?
Your Honor!
I'm simply asking Detective Leahy about his personal experience within his department.
This is the last question I'll allow.
But she had been sleeping with him, undisclosed to the court, just creating a massive conflict.
Well, no, I mean, I believe, and you can correct me if I'm wrong, they were in her office together.
Yeah, like, and why were you not there? And it was,
why were you not there? He was at a friend's.
Yeah.
Which, sure, friends.
Yep.
I mean, that's the number of conflicts of interest and violations there is mind-boggling.
And she gets him to testify that he is aware that at some point in some other investigation, someone doctored video evidence.
Yeah, great.
That's
just
okay. Is there any indication that happened in this case?
So,
or are you on this case? Was the officer who doctored that evidence on this case? What?
I mean, the judge allows the question, but I'm also like, one, I don't think would be allowed at a regular, in a trial. But two, he says yes, and it's just implied that wins them the case. Because then flash forward to her victory dance out front of the court.
Mm-hmm.
Like, one, no.
How would you... So, all right, you're the opposing counsel. You object to this testimony because, I mean, relevance, I guess.
Relevance, hearsay.
Yeah. So, I guess defense would say, well, we're trying to show a pattern that the police officers doctor evidence. It's like, well, it's not this police officer. It's not the police officers here. It's not... What is connecting it to this case?
And it's not a pattern. Asking a question that, are you aware as to whether this has happened in this office previously, does not demonstrate a pattern.
Yep.
There's no, I mean, that could be a totally different precinct 2 decades ago.
Right. And and theoretically, the cross-examination would bring that out. And and by the way, like if if this is a real case and he says yes to that, the whole room doesn't go, ooh, oh no, like the room goes, okay. Like, ask the follow-up question, which was, are you aware of that happening in this case? Has this happened in the last 10 years? Has this whatever? And the cross-exam, like theoretically, the prosecutor would have ripped that theory apart on cross-examination. But
I mean, in the real world, there's nobody sitting in the benches behind to watch, except that she's essentially forced all of her students to come watch the trial. It's so... Sorry, I'm trying to formulate my sentence that has to do... there are so many things wrong with how, by, taking this on a week before, she, isn't aware of all the evidence. She's introducing a witness that's not a rebuttal witness. It's not on anybody's list, but the judge is going to allow it because...
I'm only going to allow it up to this point. That's not how that works.
Right. No, either something's admissible or it's not. You don't get like 3 strikes.
Right.
Anything.
Also, can we talk? And this is a sort of completely side note, but how big is that courtroom?
Yeah. It will. I guess every single seat is taken up by her class. That's the.
Maybe, but that's
still, the only thing I can.
That courtroom is capable of having hundreds of people watching. Most courtrooms I've been to that would involve a criminal case like this would have 40.
Do you think she asked for a bigger courtroom just so she could bring her class? Like, oh, they're part of my firm.
No, they just, when the court clerk sees that she's on the case, it gets moved to the biggest courtroom in the courthouse.
Right.
Yeah. This is where we normally do swearing-ins and like.
Yeah, the courtroom they're in is more akin to like the big courtroom at the federal courthouse that I worked in, and that was like the big.
Yeah, this is for ceremonial things. Also, when your cases are here,
right? It's the ceremonial courtroom. They don't have they don't have criminal trials there.
You don't have basic criminal trials.
Right.
Like the Trump trial going on right now is in the big courtroom in the courthouse.
Right. And I don't even think I've been in that courtroom before. I'm confident it's about half the size of what they show in this.
Yeah. Well, it's funny if you follow the Trump trial, like there is an overflow room for the reporters. So they don't have everyone in one room.
Right. I mean, even the Supreme Court. I have been in line to go see oral arguments on a case I wrote a brief in, and was not at the court soon enough to get into the actual courtroom. I had to go to the overflow room because it turns out the Supreme Court's courtroom is like not that big.
Right. I mean, most judges' courtrooms, and again, my comparison is in New York and or DC, but a vast majority of the time, their courtrooms do not hold more than 20 spectators at most. I mean, like when we used to go for status conferences in person before they started making them more virtual, like they would have conferences where it could be upwards of like 50 lawyers there, and you'd have to sit out in the hallway and wait to be called because you just did not, there was not the space to be able to be in there. And that is how most courtrooms are, is that they don't have the space to have a huge courtroom like that, which makes sense.
It's funny when I remember in law school, because the federal courthouse was like 3 blocks away, there were a couple times where I saw that there were interesting cases coming up. So I would just go and watch a hearing because I'm that kind of nerd. and I'm the only one who's not the attorneys or the parties. And I'm just like sitting in the back. So, you know, in the state courts, when it can be this cattle call, like Derrick, you were just describing. And then on the flip side, it can be just deserted.
Right.
And I'm standing out because I'm like the one person no one knows who's just like in the back of the courtroom.
Yep.
But on a trial like this, you're not going to get...
No.
This is not the Casey Anthony trial.
Do you guys have anything else to add for the trial itself?
It's just bad. It's just bad. That's what it is.
They skip over things, and I guess that's... You know, for time, they skip over things. They don't want this to be the featured trial of the whole season, I guess. But it also leads to, like, questions of how did this one piece of evidence get in, and how does that somehow prove that the defendant is innocent?
Because we only see, what, 3 witnesses get either direct or cross-examined?
Yes,
3 or 4? We don't see the opening. We don't see the opening. We don't see the closing. Like, you don't see anything that would sort of solidify the fact that, like, she's, you know, innocent or that would have been found not guilty. Like, we just get sort of snippets that they make it seem like are gotchas, and a couple of them are, but the ultimate one, the have you seen evidence get doctored at your office previously, is not the gotcha it makes it out to be.
I mean, in Lincoln Lawyer, we got a lot of instances of Mickey knowing what he's doing and being a good criminal defense attorney. I mean, the world is really heightened, but you know, he's very competent at his job within the world of that show. There is nothing here where Viola Davis's character Keating is a bad attorney. She's not good at this job.
Yep. Yeah. There's literally nothing in episode 1 that would indicate to me, other than the fact that she's just a hard ass, is that she is a even above adequate criminal defense attorney, let alone this supposed hard ass amazing criminal defense lawyer that's like known in the area.
Can we talk about the conversation she has with Wes at the very end about you can go be a corporate lawyer and eat a bullet at 40 and hate yourself, or you can come work for me and be someone you like.
Think carefully. Everything after this moment will not only determine your career, but life. You can spend it in a corporate office drafting contracts and hitting on chubby paralegals before finally putting a gun in your mouth. Or you can join my firm and become someone you actually like. So decide, do you want the job or not?
And it's like, you have shown yourself to be an incredibly corrupt, bad attorney. Guess what? Your class is a 1L requirement. Not everybody who's in your class has any, like Derrick or me, or I think Mike too, any desire to work in criminal law. Plenty of civil attorneys do enjoy their work and do respect themselves.
I mean, plenty of lawyers who go work at a big firm and do corporate work are perfectly happy with their life. Yes, there are certain firms that are known to be worse off on their associates, and you go work there for a few years, and then you get a great job somewhere else and enjoy yourself.
Yeah. And you know what? There are criminal defense attorneys who
are actually good at their jobs and not unethical.
Are good at their jobs, or succumb to the mental stresses of the job, and maybe they hate themselves,
For the record, you want to know what would stress me out? Being unethical day in and day out in a criminal defense firm.
Having to worry that you're going to be disbarred for any of the number of the things that you did on the first day of the class.
Right. I have been stressed out in my legal career for many reasons. never once was it because I thought that we were going to get ethical violations against me.
Yeah.
But if that happened, that's ruining my week, if not my month or my year. That is potentially career ruining if I thought that there's a chance that I would be doing something that could be considered an ethical violation.
Yeah, I had a friend of mine who had an ethical complaint against them, totally baseless, but people can file just like you could file whatever lawsuit. It may not succeed, but you still can file it. You can file an ethical complaint, and even when it's something entirely frivolous, it's still an incredibly stressful experience.
Yes, correct. Now imagine you were actually doing that.
I had somebody a couple years after I started my job. Somebody called me up and said they had a friend who's an attorney, and they'd file one piece of paper and get me disbarred. I'm like,
what?
I'm trying to get lunch. That's not a thing. And I hung up on them.
I'm trying to get lunch.
I have a defendant on the other side of a case threatening to sue me for malpractice, and we've had no interactions at all other than we sent them notice of a suit against them, and I don't know, I haven't been able to respond because it's just a weird thing to say, but all right, whatever, this is a random threat out there now, great.
Yeah, and I will say there are certainly lawyers out there that threaten because they consider themselves the aggressive lawyers who they do threaten malpractice claims, they threaten ethical obligation violations, things like that. They never go through with it, or at least most of the time they don't. But it is that's the way that they think to scare you, right? And by the way, I don't want to be dealing with an ethics complaint. Jesus Christ, that would again, the amount of time and energy you'd have to put into defending it is just not worth it. Now imagine you're actually doing unethical things as part of your practice with this
day in and day out. We saw 4 in a single day in this episode.
Right.
So,
and there's no indication that that's not what she does. The indication is that is how her practice operates. She will get dirty and do whatever is necessary, regardless of whether it's proper. And that would stress me out a lot.
Yep.
Just insane. I don't know.
Let's get to the rankings, guys, because this is going to be great.
Okay.
Geoff, I want Geoff to go first because
all right,
he has. This has been 10 years in the making.
So let's see, entertainment value 3. I mean the people involved are attractive. It's well filmed. It's not well written. It's not particularly well acted by anyone, including Viola Davis. I know this performance, not this episode, but this show was in part what really put her on the map for it was after this that she got I think was it her Oscar for I'm totally blanking now. Doesn't matter. This, I realize this put her on the map, but it's so over the top and just one note the entire time. I give it a 3 for entertainment. And I think I give it a 3 for the law as well. I mean, at least they raised concepts like mens rea, even if they got them slightly wrong, and also it raised it in a way that was not at all whatever. I'm giving it a 3.
I'm shocked you gave it a 3. I'm shocked you gave it a 3. Okay, entertainment. I guess I'm at a 3. I'm not even sure if I can get myself to a 3 on entertainment, because the problem is the whole show is legal based, right? The whole show, at least for the full episode, every single scene has to do with the law, right? So we don't even get reprieves of someone just hanging out at their house talking to a human.
No, we get
it's
the Wes and his neighbor. Wes kind of trying to talk to his neighbor.
Okay.
About her loud music.
True. Okay. So we have 2. I think that's 2 scenes, right? two scenes that are not like either at law school or at a trial or interviewing a witness, whatever. So the vast majority is the legal stuff, and they get it wrong every step of the way, with one exception, which is like maybe the first scene in law school, which is sort of correct, like the cold calling aspect of it, which again, as we discussed, has 6 other things that are wrong with it, but the general concept. Entertainment wise, I'm going to say it's a 2. And it's just because I can't get past how bad the legal stuff is. Like, I wanted it. Like, she's a phenomenal actor generally. I don't think this episode demonstrates that. I think she's either on extreme in this direction or she's on extreme in this direction. Like, it's just a variety of extremes.
Yeah.
I don't think this actually shows her acting, demonstrates her acting very well through no fault of her own, is what she had to work with. And the other, like, there's no other characters that sort of jump out as being phenomenal actors in any capacity.
Yeah.
And I'm just not it's so legally bad I cannot be entertained by it. So I'm gonna go with a 2. Okay, I don't know how you gave it a 3. I really don't. I think it's a 1, and it is just because it's just, if I could give it a 0, I would contemplate it. But like, I think it's at best a 2. I'm giving it a 1. I can't. It's just so wrong.
Okay. Legally, I'm with Derrick on this. I would give it a 1 for just how it got. The only thing that's right is actus rea and mens rea, and cold calling. For entertainment purposes, yeah, they're. It wasn't like agony to watch. Like if I'm ignoring the legal aspects of it, it was not agony to watch them on screen. It's just like it felt like a normal, like it felt like a show from the CW, just like. Oh, yeah, this is what people watch sometimes. So I'm fine giving it a 3 for just entertainment value. Like 3 out of 9 seems pretty bad to me.
I want to try and articulate why I wound up at a 3. Because, yes, mens rea.
Okay, this is, ladies and gentlemen, the rebuttal of Jeff Blackwell.
Yeah. There are a lot so I have to acknowledge that some of the things that piss me off about the way she works appear to have been intentional. Like, they know that you can't that you can't get an email and just like introduce it the way she does, and they foo-foo around it, but they acknowledge that is not how things are done. So it's kind of like. In Spider-Man Into the Spider-Verse, he gets 0 on a true-false test. So the professor knows he knew the right answers and intentionally picked all the wrong answers. And I feel like there's an element of that here. They knew, like, there's stuff that they know, and maybe it's going to pay off later in the season, in later seasons. I can't say, but there's at least enough of a tip of the hat to the fact that she's doing things not the right way that that I wound up at a 3.
You are allowed to do that. Well, here's the thing: is we're never going to learn if it pays off, because I'm never going to watch this ever again. No. So for those of you listening would like to tell us if it pays off, you're welcome to tell us, but I don't think any of us are going to actively try to find out.
Right. Unless episode 2 or 3 is her getting disbarred and a new star comes in.
I think we know that doesn't happen.
Yeah.
The Not So Grand Jury is sponsored by Morwa P. LLC.
The opinions expressed in the Not So Grand Jury are those of the hosts themselves and not of their respective employers.
The theme music for the Not So Grand Jury is from Gustav Holst's Jupiter and is in the public domain.
If you'd like to get in touch with us, if you want to suggest future movies, or even if you want to offer corrections, you can email us at notsograndjury@gmail.com or message us on any of our social media accounts.
The Not So Grand Jury is copyright 2024, all rights reserved.